15. The purported title of the 8 defendants to counterclaim in the circumstance of this case is defective. As such, he is not entitled to 2.5 hectares of land he purportedly purchased from Mabel Okwonu. 16. The 11 defendants to counterclaim defense cannot stand and cannot vitiate the counterclaimant's case because it was filed and prosecuted by a person other than the 11 defendants to counterclaim. 17. The witness statement on oath purporting to be that of the 11 defendants to counterclaim was signed and adopted by a person other than 11 defendants to counterclaim. As such, it is not a valid defense. And 18, in view of the invalid defense of the 11 defendants to counterclaim defective defense, the case of the counterclaimant is not vitiated. Then the counsel for the counterclaimant made reference to judicial and statutory authorities in support of his submission, which this Honorable Court shall make reference to if need be in the course of the judgment. He urges the Honorable Court to hold that the counterclaimant is entitled to all his reliefs. Then the counsel for the 8th defendant, Anthony Adoye Esquire, in his final written address formulated 2 issues for determination as follows. 1, whether in the circumstances of this case, the defendant counterclaimant has proved beyond reasonable doubt his allegation of forgery against the 8th defendant to counterclaim. 2, whether the 8th defendant to counterclaim has proved its title to 3.3 hectares being part of the land in dispute, having lawfully purchased same for value. Arguing issue 1 and 2, the counsel for the 8th defendant submitted that the defendant counterclaimant has not proved the offense of forgery against the 8th defendant beyond reasonable doubt as required by the extant law of the land. He cited judicial and statutory authorities in support of his submissions and urged this Honorable Court to discountenance with the allegation of forgery and or fraud against the 8th defendant to counterclaim and hold the title of the 8th defendant to counterclaim to the land in issue as valid and properly obtained. Then the counsel for the 11th defendant, A. Na'ala, in his final written, A. Na'ala Esquire is there, please, so that you Esquire, in his final written address, formulated 2 issues for determination as follows. 1, whether the defendant has a valid counterclaim before the Honorable Court that would clothe it with requisite jurisdiction to determine same. 2, whether the defendant has discharged the onus placed on him by law to entitle him to judgment. Arguing issue 1, the counsel for the 11th defendant submitted that the defendant did not satisfy the requisite condition for the grant of an order for joinder. This is because at the time of application, the defendant did not accompany his application with the statement of defense, exhibits intended to be used, and the positions of all the witnesses he intended to call. He cited the relevant provisions of the rules of this court and also submitted that the motion for joinder was an incompetent motion as it did not comply with the requirements of the law, and that since this Honorable Court had no jurisdiction to grant an incompetent motion, the order made is a nullity, and therefore this Honorable Court has jurisdiction to set it aside. Arguing issue 2, then the counsel for the 11th defendant submitted that the defendant has not discharged the onus placed on him by law to entitle him to judgment. He also submitted that it is not enough for a party relying on traditional history to name the persons through whom he claims without establishing the particulars of the intervening owners through whom he claims, by an unbroken chain of succession down to him. But the evidence of the 11th defendant to the counterclaim is more probable than that of the defendant. Counsel cited judicial and statutory authorities in support of his submission and also made reference to the evidence of the witnesses on record and the pleadings in support of his submission, and urged this Honorable Court to hold and resolve issue number 1 in favor of the 11th defendant to the counterclaim and dismiss the defendant's counterclaim. Sorry. Having summarized the evidence of all parties and their legal submissions, and in order to determine this suit, it is necessary to consider whether, having regard to the burden of proof in civil cases, the plaintiff has proved his case to entitle him to judgment. Invariably, it is necessary where the plaintiff pleads and traces his root of title to a particular family or person, and as to how title vests in him, he must establish title by credible evidence. See the case of Nduku versus Archer, citation as provided, The plaintiff in an action for declaration of title to land is required to satisfy the court by evidence and not by admission in pleadings of the defendant of his right to declaration he claimed. See Bello versus Iweka citation provided. How then can ownership of land be established? Ownership of title of land can be established through one of the following ways. 1, by traditional history. 2, by production of documents of title duly authenticated and executed. 3, by acts of ownership extending over a sufficient length of time, numerous and positive enough as to warrant the inference of true ownership. 4, by acts of long possession and enjoyment. 5, by proof of possession of connected or adjacent land in circumstances rendering it probable that the owner of such connected or adjacent land would in addition be the owner of the land in dispute. These methods were initiated in the case of Idundu vs. Kumagwa citation was provided and started with approval in the case of Falaye vs. Dada 2016 for ACNJ at page 119 to 120. Flowing from the above, I have formulated 2 issues to determine this case. Thus, 1, whether having regards to the pleadings and evidence on record, the plaintiff has, on the preponderance of evidence, proved his case as entitled to the judgment of the court. 2, whether the defendant counterclaimant has, on the preponderance of evidence, has discharged the onus of proof placed on him by law, prove any valid title to the land to be entitled to the judgment of the Honorable Court. On issue 1, whether having regards to the pleadings and evidence on record of the plaintiff has, on the preponderance of evidence, proved his case as to the entitlement to the judgment of this case, it needs to be said that all the 5 methods of ownership of land, where title of land is in dispute, do not have to be proved to be present before proof of the said ownership can be said to have been established, as only one of the methods above stated is sufficient. And this, the plaintiff must prove by cogent, satisfactorily, and conclusive evidence. See Olagunju versus Adesoye citation as provided. In the case before me, the plaintiff Francis Phillips has predicated his claim of ownership of the disputed land purchased and by traditional history. The defendant counterclaimer Edward Pam predicated his claim of proof of title by production of documents, while the 8th defendant hinged his claim of title to the disputed land by production of documents. The 11th defendant is predicating his title to the disputed land on traditional history. A claimant of title to land relying on traditional history or evidence, grant, inheritance, or possession must plead and prove such facts as 1. A, who founded the land in dispute. B, how they founded the land. And C, particulars of the intervening owners through whom he claimed. See Opoto versus Anno citation as provided. It must be noted here that traditional history in simple terms is the history of a family or a community and may be relevant to a claim in which title to a subject matter or a right or interest is sought to be established to obtain a declaration as a principal relief or in order to be protected by an injunction. Although evidence of traditional history is hearsay, it must be a true account such that it was not contradicted, or at least have a semblance of it, in the sense that it is not incredible, even though it may not always have the sanctity of truth. It is an established principle of law that in a claim for declaration of title, as in the case instant, the evidential value of proof, the evidential burden of proof is on the plaintiff to establish his case and to succeed on the strength of his case and not to rely on the weakness of the defense. See the case of removal as Commissioner of Agri, Natural Resources, Asaba, citation provided. The only exception to this position is that a plaintiff may quite perfectly take advantage of those facts in the case of the defense which supports his claim. See the case of Brahmo versus Mangos, citation provided. It must be stressed here that the party that is able to prove his title to land in issue is deserving of judgment. Flowing from the above, it is on record that the plaintiff's suit was struck out on the 11th day of September 2019 for want of diligent prosecution. The plaintiff had called one witness prior to the striking out of the case, and as stated in the course of this judgment, the plaintiff did not file any application to release the suit, and he also absented himself from the court throughout the proceedings. The plaintiff called only one witness, Sule Yamu, who testified as PW1. As stated in the summary of the evidence of the case of the plaintiff above, the plaintiff claimed in his statement of claim that his father purchased the land measuring 1.81 hectares. The plaintiff did not testify to give effect to the pleadings, and no document of title was tendered to prove the alleged purchase. The plaintiff's pleading is purporting